Welcome back to another lesson of the Land Law Made Simple series, where I have a look at different concepts in land law, and I try to break them down into really simple points to help everyone understand some of those concepts which can be quite complex and difficult to grasp. So in this lesson we have a look at easements. Let's jump right in. So easements, what are those actually? If you've seen some of the previous videos from the series, you will already know this. An easement is basically a right to use someone else's land for a certain purpose. So the most common example really is a shortcut, a right of way, something like that. So, for example, if you're allowed to use your neighbor's driveway to reach your own house, or to access the road, or to access I don't know, well, or whatever there might be. So those kind of things count as easements, and it's important to distinguish them from profits. Um, Profits really are rights to take something, like a physical thing, from someone else's land. So it's not really a right of use, but a right to take an item. And very often those are things that grow naturally on the land, like chopping wood, for example, or you might be allowed to dig some gravel. Maybe you might be allowed to fish in the lake, or something like that. So those will be in relation to natural items, really. Okay. Um, so that's the main way to distinguish them. Easements are just using the land, um, doing some kind of activity or whatever. Whereas a profit, you're actually taking certain natural resources from the land. Okay, now easements, that's where land law now starts getting a bit more tricky. So we need to have a look at key terminology that you will probably encounter in problem questions, or essay questions, exams, whatever might be coming up. So it's really important to know at least those key bits of terminology. Otherwise, you will really struggle to cope with, for example, the SBAQs that come up in your solicitor qualification exams. So the main thing is the distinction between dominant land and servient land. So dominant land is the land that benefits and gets the advantage. So that should be quite clear. It's pretty self-explanatory, although maybe not the ideal wording for it. You will get the gist. It's just a bit of an outdated word, really. Obviously, this also means dominant owner. This is clearly the person who owns the dominant land and who gets all the benefits. Okay. By contrast, we have the servient land is the land that carries the burden, the disadvantaged land, the land that we are talking about mainly, where you have the right of use to access that land, okay, and it serves another piece of land basically. And obviously that also means that the owner of the servient land, the servient owner, is the person who has to bear the burden and who has to put up with the other person's right of use. The other key distinguishment we need to make is between a grant. So this is basically if I decide to give, for example, my neighbor a certain right of use, and there's nothing about any kind of change of possession at all. It's just some kind of agreement I am making for whatever reason I might have. Reservation, that links up to a change of possession. So when I then decide to maybe sell part of my land, maybe just a small little area like a garden shed, a barn, a small garden plot I don't use, something like that, but I do want to have some kind of access because I've got storage there or whatever, and I keep this right even though I'm selling the land. That would then count as a reservation. Okay, so that's the two main things we need to be aware of. So one is dominant land versus servient land, and the other grants versus reservations. So let's just have a look at this in an example to make it a bit clearer. Let's say that Graham sells his barn to Thomas. This is only a small part of Graham's land, and it's not really accessible from the main road or anything, so Thomas needs to use a track across Graham's farmland, so the land that Graham is still retaining for himself. And this right of way would clearly be an easement. However, Graham, even though he's selling his barn, he still needs the drains that are running under this building. And so he has to reserve a right for himself. Even though he's selling the barn, he still needs some kind of access really to it to get to the drains. Okay, so here we can see in one example both a grant and a reservation. And we can also clearly see what is the dominant land and what is the servient land. So for the barn, this is the dominant land for the right of way because it benefits from the right of access, the kind of shortcut across Graham's farmland. But it's also a servient land as well for the access to the drains. So both can exist at the same time. Okay, whereas the farmland has to bear the burden of having a right to use the track across the farmland, but obviously it does benefit really from the access to the drains. It's a bit complicated, but just don't be afraid to have a look at those things in detail. If you see, oh my god, there's so many different things going on, there can be multiple sets of rights in a land, But if you think about clearly and maybe have a little table where you set up everything and you think about it slowly, gradually, it will become clear. So in the beginning, we have this barn that is being sold from Graham to Thomas. Okay, that is a change of possession. Now, even though the barn is being sold, the surrounding land or the farmland and stuff is still owned by Graham. Okay, so because we have a bit of a difficult situation now, there's not really a road or anything, a public road leading to the barn. It would be really difficult for Thomas to actually access the barn. If not, there was a right of way granted to through the surrounding land that's still owned by Graham. It's kind of necessary for him to use the little track because there's no public road, no highway, no anything that he could use. Okay, so that's the first easement, and that's something that is being granted to another person. Okay, so originally Graham is the owner, and he grants this right of way to Thomas when he buys up the barn. Now, also at the same time, Graham still needs some access to the drains, and he needs the right to use the drains. And so this is a separate easement that exists at the same time, and this is being reserved by Graham when he sells the land. So even though he's actually sold the barn, he still needs to retain some rights over the land, because those drains are obviously really important if he wants to manage the farmland well. Okay. Now we need to have a look again at legal status as well, which is a question that comes up all the time with land law in different areas, but it will be the same principles applying that we've seen before. So, as always, we need to have a look at the Law of Property Act to see when an easement will be legal or when it will be equitable. So same way as we've seen before with the freeholds and leaseholds and that kind of thing, easements also need to have a very defined duration. So either, same way as a freehold, it can be forever, so as close to forever as we can possibly get in English land law, and you basically have an unlimited right to the property, and you've got inheritance rights as well, so you could give this to another person in your will. The other option we have is if there's a fixed term of a certain duration. So maybe I say, oh, you can use the track across my land for 2 years, or 6 months, or whatever. Maybe I know that there's a public road being built, but it will take some time. So until this one certain date, you can use the track across my land. but this right will then stop at a fixed point in time. If there isn't anything specified, then the easement cannot have a legal protection. So as long as you like, or for your lifetime, or anything that is not really certain, then might be protected in equity, but it's not a legal right with legal protections. So these concepts should be familiar to you anyway if you've seen the previous videos. But that's just something that you will need to know for all kinds of things like easements, freeholds, leaseholds, and so on. So forever or fixed, that is something that has legal protections. If it's not quite clear when this might come to an end, it can only be equitable. Now, as always in landlord, really, we have very strict rules how to create an easement. Normally, you will need a deed, so a special signed legal document where you've got witnesses. It needs to say that it is a deed as well, and obviously signatures are required. So that's the normal requirements for an easement. There are a couple of exceptions when we look at implied easements in a future lesson, or we've got something called prescription as well, which you might have heard before from Todd's law, for example. But those are things we will look at in future lessons. But for now, just remember that most of the time you will need a deed, and there's a couple of exceptions. But if you want to have something that's legally protected, you should make sure you definitely have a signed document there. Now, land law obviously can be an area of the law where people spend large amounts of money and everything is a bit complicated. Transfers of a certain piece of land can take months and years. So people will often start having a written contract in the beginning where they say, yes, we want to do that, but we need to do the actual formalities at a later point in time. So even before you've got the actual deed and all the requirements fulfilled, equity might still step in to protect it if you have already got a written contract and you just decided that the actual formalities will come at a later point in time. Again, that's something we talked about in previous lessons, so you might want to check those out if this is a concept that you're struggling with. But basically, a helpful analogy might be to think of a deed as the official marriage certificate. And a written contract then would be a bit more like an engagement. You've got some form of recognition there and some rights that come along with it. but it's not quite yet the full deal, so you don't quite get all the legal protections of an actual marriage. It's a pre-stage that's important, and that is widely recognized, but it's not the full deal. Now, this is now where it gets a bit more tricky. In the case of Re Ellenborough Park, it's been decided that an easement needs to have four really essential aspects or conditions that need to be met in order for it to count as an easement. If even one of those conditions failed, it will not be an easement. The first one being that we need to have two pieces of land, distinct pieces of land, and one of them must be the dominant land and the other the servient land. So remember, one land has to benefit and the other has to bear the burden. Okay. Now the next one is a bit trickier, because in our Ellenborough Park it was decided that the right must benefit the dominant land itself. What does that even mean? So the main idea is that, for example, a right of way or something has to increase the value of the land itself and has to accommodate the land itself, rather than just the person who is now becoming the owner or who's living there or who is using it for their business, something like that. So it has to be something that attaches to the land and accommodates the land itself, rather than any kind of owner and their interests. The next one though is a bit easier again. It just means that the two pieces of land, so the dominant land and the servient land, need to be owned or occupied by different people. That's a fairly self-explanatory one. And then the fourth one, that's another one that is quite tricky and complicated. And it says that the right must be capable of being granted, which is a bit of a weird phrase again that doesn't really tell you much. But we have a look at each of the four conditions in more detail. So firstly, that it is the requirement that we need a dominant and servient tenement. As we said before, this means that we have one piece of land that benefits and another piece of land that is being burdened. And the easement then attaches to the land rather than a person. The main idea here is that you can't have an easement in gross. That is the way the land law names it. In gross means that it's just a floating one without any actual dominant land that is benefiting from it. So if you are claiming a certain right for yourself, but there isn't really any piece of land that benefits from it, nothing that is identifiable, or maybe there isn't any parcel of land that's being burdened, then this means that the easement must fail. And a classic example for the first condition here, the first essential, is that you need that you have, for example, a right of way across your neighbor's land. Obviously, you and other people who live at your place, or really the land itself, benefits from the right of way, because it's another, or maybe sometimes the only way of access. And if you decided to sell your land at some point, then obviously this is quite a valuable thing to have for the person who might be interested in buying, and they will almost certainly want to retain this right of way. Now let's come to the second essential, with benefit for the land itself. So, as I've mentioned before, this basically means that the land has to now be more useful or valuable, because of this new benefit that attaches to the land. And it can't just be a personal favour to whoever is occupying the other land, the dominant land. It has to be something that is some value for anyone who's just wanting to use the land ordinarily for their own enjoyment in a normal way of conduct. So not anything really eccentric or weird, that's just unique to a certain occupier, but something that would be quite helpful to anyone who would own the land in the future. So the courts basically ask, would any reasonable person owning that land see it as a benefit? And that's not just a specific current owner with any kind of weird, eccentric, particular desires, but really any kind of reasonable person. And again, classic example would be a right of way, which makes the land accessible. So that would obviously benefit any kind of reasonable person, not just some eccentric owner. By contrast, what would count as really eccentric and particular, like a personal favour, that can be seen, for example, in Here Re Tapper, where the new owners had a boating business on a canal, and it was said that this helped the owner's business, but not really the land itself. And if someone else would buy the property, then, well, they don't really need to use the canal to make any business. That's a bit particular, really. So it's not seen as something that is really essential for the land. Now, don't worry, it gets a bit easier again with the third essential. So this is just a requirement that things need to be owned by different person. You can't really grant an easement over your own land, although this would be recognized as something called a quasi easement. It doesn't become a real easement at all. So, for example, if Alice has two plots of land, maybe some, I don't know, garden allotment, something like this, and even though those pieces of land are separate, maybe there's a fence or any kind of wall or other kind of dividing line there. She can't really grant or reserve an easement from A to B because she owns both of them. That wouldn't really make any sense. That she then needs to draw up a deed with herself. That doesn't even work because you can't have a deed or a contract with just one person. Always needs to have at least two. So for all the time being that she owns both plots of land, A and B, she can't really claim an easement. Only if she then later decided to sell one of those two plots, then that's where we can finally realize any easements. Now, the fourth essential is the one that is perhaps the most complex and difficult, and that's in relation to whether the easement is capable of being granted. Now, unfortunately, this one has another set of 4 sub-requirements, which you will also need to know. The first one is fairly self-explanatory, and it just says that the easement has to be sufficiently clear, so everyone needs to be able to understand what is meant if they see the easement. So, for example, you are purchasing a new property and you come across the easement on a particular deed, you should be able to understand what is actually going on and what rights you now need to pay attention to. If it's something really vague that isn't capable of being understood by everyone, then it might be that the easement is not valid. Now, the second sub-requirement is that it cannot impose really heavy obligations. And in particular, this means that you cannot force the servient owner, so the person who owns the burdened land, to spend any amount of money. So you can't just say that, I don't know, they have to spend like a couple of £100 for a certain easement or things like that. Normally it has to be something that is free of any charge, like a right of way. Obviously, this means that you can just use the track over land, but the other landowner won't have to pay anything really for it. There are some kind of odd cases where this deviates a little, like maintaining a fence. Obviously, fences do cost a bit of money to maintain. Maybe you have to repair it, maybe you have to paint it, that kind of thing. But for the most part, there shouldn't be any huge amounts of money that the servient owner needs to spend. Now let's come to the third sub-requirement, and this is also something that causes a bit of complexity and some problems. And it says that the easement must not give full possession or control. So, for example, you wouldn't be able to claim someone's entire cellar. You might be able to claim a small part of it to do some storage and, I don't know, leave some items, but you wouldn't be able to take up the other landowner's complete space. So another way of saying it is it cannot be so extensive that the servient owner practically loses possession or control over their own land. And lastly, we have another slightly more tricky thing, which is that there are only certain negative easements which are being recognized by the law. Now, what are positive and negative easements? Now, a positive easement, they allow you to do something. So it allows you to walk across your neighbour's land or to hang a sign on your neighbour's land to, I don't know, draw attention to your business or something like that, or it allows you to drain water or do any kind of activity. The negative easement is basically the opposite in that it now stops your neighbor from doing something. This basically means that your neighbor or the servient owner or whatever kind of relationship we're talking about cannot interfere with certain really essential rights that you have. And we're talking about really essential, absolute basic rights only. Because really the law only recognizes 4 rights. So one of them is the right to light. So if you buy a building, for example, or a flat or anything, and you want to live in that building, then your for example, neighbor wouldn't really be allowed to build a really high wall right next to your window so that no light's coming in anymore. So that would be an example where they can't interfere with the really basic right to just have a little bit of light or a little bit of air. And then likewise, they can't interfere with any kind of building supports, or they wouldn't be able to interfere with any existing flow of water. So, for example, if there is a river or stream or something that is running across your land and the land of your neighbor, a negative easement would, for example, mean that your neighbor isn't allowed to build a dam or interfere with the water, so that obviously you will still be able to enjoy access to this river as and when you need it. So those are the 4 ones that are recognized in law. Unfortunately, the courts do resist allowing any other negative easements than those 4, because they think it could freeze development. So as of now, really the only 4 accepted ones are the ones that light, air, support to a building, and flow of water. Let's have a look at some practical examples so you can see how this whole talk about easements actually applies to real life scenarios. So one example would be some kind of storage rights where you have access to another person's land and you can store items there. So, for example, in White versus McAdam, this was a coal shed. Obviously, these days, people don't have coal sheds anymore, really. But a seller might work the same. For example, if you have some kind of seller and you allow another person to use it, the other person would be able to store a couple of items, but certainly not take over the whole place and just make cram it so full of their own stuff that you can't use it anymore. So yes, storage is okay, but only if it's limited. If it's really much, then the easement will fail because it would just go too far and it would basically amount to a joint possession rather than just a dominant land and a servient land where you have a small right of use. Another tricky thing are parking rights. So in Bachelor versus Marlowe, the servient owner had a really small patch of land, just a little green strip really, and it only had space for 6 cars. And the dominant owner, so the person benefiting from the easement and right of access really, then stored 6 cars on that land, so the whole land was covered. And the other person, the servient owner, then couldn't do absolutely anything with the land anymore. They couldn't access it. They were absolutely left with nothing. And so the court said that's going a bit too far. You're not allowing this because the person who was actually owning the land, was paid money for the land, was on the title deeds and everything. Now it's left with no use of it. That's not okay. Now, there is another test for this, and that was decided in Moncrief versus Jameson, and it suggested that the test shouldn't be whether you have anything left of the property, but who's got the ultimate possession or control. Normally, most courts really stick with Bachelor versus Marlowe, but just keep in mind that there are different ways of seeing those kind of things. So, just an analogy to help you remember and visualize this. An easement is like borrowing a room in someone's house. So you can have a spare room, a limited space, maybe an attic or something like this. But it's just not okay if you then decide to take over the whole house and use all the rooms, completely change all the furniture and so on. That wouldn't be allowed. That would be too far. Okay. A couple of other practical ways of seeing those easements would be a right of light, as we've talked about. So again, that's only something that needs to be really clearly identified. If it's really vague, like, oh, I just want to have some light, that would probably fail. But if you say in the easement and the relevant deeds and so on, that you just want to have some light in your living room through one particular window, this would be something that's capable of being understood by everyone. It's really clear, it's defined, and so the easement can exist. So while right to light is a really basic requirement, a basic need that is universal and should apply to everyone, you will not have a right to a view. And you can't just see your neighbour because they're blocking your nice view and maybe putting up a fence or anything. That is not something that's being protected in law. Right to light is something different because it's really important and essential, but you don't have a right to have a nice view. That doesn't exist. By contrast, as we've seen in the case of Re Ellenborough Park, so where this whole idea really stems from, is that recreation rights can count as easements, like the right to use a garden or a swimming pool or even a communal golf place, I don't know, something like that. This can count as an easement, but again only if it does benefit the land itself, it increases the value of the land, and it's something that any kind of later owners who might take over the land might also reasonably think is useful and valuable to have. So no really eccentric personal favours would be protected as easements. So lastly, obviously this is a lot of information. It can be really tricky to remember. It's a bit confusing to have those 4 essentials for the easements and then another set of 4 subcategories. So it can be a massive difference if you come up with memory aids and short phrases to remind you, things like that. So unfortunately I haven't found anything that really makes it stick, but you might just think about DABC. So you've got D for dominant and servient land, A for accommodating the dominant land, B for both lands must have separate owners, and C for capable of being granted. So this might be helpful to remember the 4 key essential conditions for an easement. If you come up with anything else that is even better, just let me know in the comments.